Going through the breaking news, Supreme Court has rejected the bid to restrict access to the abortion pill, essentially saying that it is good to go. But it really is a bigger sort of ruling than that. And we're going to break that down. This was a 9-0 ruling, by the way, which I think is a lot of people are surprised about this. Obviously saying that not restricting access to the abortion pill. Now, there are some reasons, because you may be, well, how could a Justice Thomas and a Justice Alito, or some of these ones of more conservative values, how could they vote for this? But it is breaking news, essentially saying there were no grounds for this lawsuit to even take place. It had really little to do with the fact that it was an abortion pill. It had to do with the fact that they didn't feel that there was standing.
This case was captioned in the Alliance for Hippocratic Medicine versus the Food and Drug Administration. It was originally filed in district court in Texas. And what the Alliance for Hippocratic Medicine was arguing was that the FDA, even when they approved mifepristone for use for what they call medical abortions, it's an abortion pill, effectively, that they didn't go through the proper channels, even approving it back when it was first approved. But then after the fact, that they progressively more loosened restrictions on the prescribing of this. There was even mailing it and things of that nature, that they were saying even after approval, they didn't go through the normal safeguards that the FDA would have when regulating a medicine, in this case, an abortion pill. So this case went through the district court system and made it all the way to the Supreme Court of the United States. We did file some amicus briefs on this because we did believe that some of the underlying legal issues were right. However, what the Supreme Court found was that the Alliance for Hippocratic Medicine, the group that sued to get this taken off the market, didn't have standing to bring this suit.
You don't want to say a silver lining in this, but there is a silver lining for future cases in this decision.
Yeah. And, it is obviously you see this ruling and you think, like you just said, oh, gosh, this is, a defeat. But it's a technical legal thing. And when you lose on standing, and this is just kind of a general thing, you have to have an injury. You have to be injured, personally injured, to be able to bring a lawsuit. And here, the court, I think, rightfully acknowledges that they have no injury. In fact, they're saying that it's downstream, and they're not the doctors that are prescribing mifepristone. They're not a pregnant woman who's possibly taken mifepristone and had terrible consequences happen because of these, released kind of and relaxed restrictions. And I don't know if you went over this, but, in 2000, that's when mifepristone was first prescribed. And then, and at that time, it could only be prescribed up to 7 weeks of a pregnancy. A doctor must have prescribed it. It had to be prescribed by a doctor, and you had to have 3 in-person visits. In 2016, the FDA then starts relaxing these regulations and says, well, now you can use it up to 10 weeks. And guess what? A doctor doesn't have to prescribe it. It's just a healthcare practitioner that can prescribe it. And you don't have to have 3 in-person visits. You have to have 1 in-person visit.
Right.
And then we go to 2021 and they're like, you know what?
Loosening.
You don't have to have any in-person visits, and you don't. So I can see that there is a client, a plaintiff in this case that has been harmed by what the FDA has done, because there is an argument that these are not legal changes that they've done, but this entity was not the one to bring it.
Effectively, they didn't even look at the merits of the legal argument, the things that we were arguing in our briefs of why it maybe should be regulated differently, or that the FDA stepped out of bounds in their safeguards. But the Supreme Court didn't get that far. They said, look, this group doesn't have standing. There's no harm that they can point to this group specifically. And therefore, 9-0, this case is overturned.
A true client and someone that said, hey, I took this pill and had these kind of medical complications and I want to sue them.
There are absolutely legal concerns. And the court even gives a nod to that,
right,
that there are legitimate legal concerns about mifepristone and how the FDA has approved it and how they have relaxed, their restrictions. And so there is a legal argument. And I don't discredit anybody for trying it, but to just say, okay, standing is an issue. And the Fifth Circuit, they said they had standing. So this was an issue where a lower court had decided, yes, they're standing. But trying to find that really good plaintiff so that you don't even have to get into these arguments that are kind of the technical arguments.
The legal side, but the legal, technical, law school, analytic side, not to do with the people or the case or the actual issue that's at hand.
That's right. Because again, I do think there is a claim to be made that what the FDA has done is not right and can be legally attacked. You just have to have the right plaintiff to bring that case.
Now, we told people there is a little bit of a silver lining here, and this comes in the form of the concurrence by Justice Thomas. Clarence Thomas is known as arguably the most conservative member of the Supreme Court. He's the left's favorite person to attack because he is so conservative.
Alito now. I feel like
that's right. Now Alito, he's taking some
headlines.
of Clarence Thomas's love there, but he wrote a concurrence, and he said he joins the court in full on their rationale of standing. And so when you're hearing this from Clarence Thomas, you have to set aside maybe what you wanted to happen and think, I trust his legal jurisprudence. I trust his rationale. He's one of the most logical members of the court and typically delivers for conservative victories on the court.
His statement was basically, so just as abortionists lack standing to assert the rights of their clients, doctors who oppose abortion cannot vicariously assert the rights of their patients. And why this is so important is because every time we have a case or pro-life law that's passed, it's usually Planned Parenthood. It's usually the abortionists that come and bring the cases on behalf of their patients. And so this is an opportunity where Justice Thomas was able to say, abortionist cannot do that. We're ruling in this case that this, pro-life alliance can't do it. But let me explain to you, that also means unequivocally, exactly, that these abortionists cannot bring those cases. So I kind of figured that's what I would read somewhere in the opinion of, he is absolutely saying in the future, we're going to throw out these cases on standing when the pro-abortionists bring them.
What Justice Thomas was trying to point out is that we don't need more options for lawfare. We don't need to have this associational standing where a third party can go out and continue to bog down the legal system and bog down people that would have to defend themselves against that type of lawsuit if they don't have proper standing. And so to even the caller's point, and as we've talked about here, I think that is a win for the legal system. It's unfortunate that it was the wrong client to take this case forward because they couldn't get to the legal merits, but hopefully it will put a damper on the use of the left, who love to use the courts as a weapon to be able to do that in some way.